Hi, good morning. Is the county ready? Okay, all right. Good morning, everyone. The time is 9:03. My name is Christian Waugh, and I hereby bring the Citrus County Code Compliance hearing for June 2025 to order. For these hearings, we normally follow an agenda, the agenda that's posted publicly. So I will go down the agenda that you may have a copy of, and we'll stick to that today. The first item on the agenda is the call to order. The second item is the pledge to the flag. So I'd like to ask you to join me for the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you all.
Good morning.
Good morning.
If any person decides to appeal any decision made by the Code Compliance Special Master with respect to any matter considered at this public hearing, he or she will need to ensure that a verbatim record of the proceedings is made, which record shall include the testimony and evidence upon which the appeal is to be based.
The next item on the agenda is the minutes from the Wednesday, May 21st, 2025 hearing. I've reviewed the proposed minutes. Are there any other proposed revisions, modifications, deletions, that kind of thing? Hearing none, I'll go ahead and approve the minutes. Okay. Ladies and gentlemen, good morning. Again, my name is Christian Waugh. I'm a licensed Florida attorney acting as what is called a special master. That's a fancy title created by the law, but what it means is that Citrus County has hired me to preside over this hearing. What I'm going to tell you during this opening statement applies to all of your hearings, so I'd appreciate it if you'd pay attention. When your case is called, please come forward. You will be placed under oath. If you are appearing at a hearing like this for the first time, the county will call its case, and I will allow the county to present its case. You will have an opportunity to cross-examine any of the county's witnesses, and then you will have an opportunity to present your case regarding the violation. That will be your opportunity to present evidence and make legal argument. It is important that you take your time during this process because it'll probably be your only chance to make your case to me. I will also ask whether or not you are contesting the violation. If you do not contest that a violation exists, I'll assume that there is a factual basis for the violation and proceed to ask how much time you need to fix it. This will help save time for yourself and others. You are by no means required to do so. If you oppose the case or simply want to be heard, you have that right. At any time during the hearing, I may have questions of parties, witnesses, or staff. Before issuing a ruling, I will ask if there are any members of the public who wish to speak. And if there are, such members of the public will have one opportunity to speak per case. Such right to speak is not unlimited, and the comment should be focused on the case and made as succinctly as possible. Although persons may be upset or even passionate about what they have to say, all witness testimony must remain civil, and you must not interrupt other witnesses, parties, or attorneys. In most instances, if you are found guilty of a violation, the law requires that you be given a time to comply before a fine begins. You must fix the violation by the date that I give, or the fine will accrue for each day that you remain in violation. The law then allows Citrus County to impose that fine as a lien on all of your property. The county has the right to foreclose on that lien or seek a money judgment against you after the lien has been recorded for 3 months. I encourage anyone here who has questions about that or their rights or responsibilities to seek their own legal counsel. In all cases in which I find that a violation has occurred, I will impose all costs required by county law. I incorporate these into my orders as standard provisions. If you bring your property back into compliance with the code during the time that I allow, the cost will remain minimal. But if you do not timely fix the violation, you will be responsible for additional costs. Although it's only happened a few times as a special master, I may continue your case if I find the need for further evidence or argument. You do have the right to appeal any order that I make today as provided by law. Thank you.
First case on the day's agenda, Eugene Joseph Hill Jr. and Karen Hill, page 25 of your agenda. Expert on the case, Joanna Coutu, case number CE 2025-246.
And Your Honor, as the parties are approaching, I've been advised that they've discussed the matter. No contest for $3,000 one-time fine is what's been advised.
Okay.
Can you come over here?
Good morning. Can you raise your right hand? You swear to tell the truth, the whole truth, and nothing but the truth?
Good morning, sir. Can I ask you to put your name on the record?
Eugene Joseph Hill, Jr.
Okay, thank you. And you did hear the Assistant County Attorney say that y'all have reached a resolution without needing to go through the hearing.
I realize that.
And was that resolution that was put on the record accurate?
I guess if that's the fine.
Well, I mean,
I'm not contesting.
you're not contesting the, okay.
Yeah,
Can you tell me just a little bit about what the county's case is?
So this property was vacant and, I'm sorry, okay. And when I did my initial inspection, it looked like they had taken down some trees. He said they only took down trees that were diseased, but they did bring in a bunch of fill dirt and grade.
And that's the rub, you know, sometimes, I mean, even when the dead trees are taken down, I believe county law requires that it be occurred through a certified arborist, and that's just a check, so.
we went through an arborist.
Oh, you did,
but
okay.
The dirt.
No,
we
I know,
just-
that's tough, so. And the reason for that, I put this on the record so that other people in the public understand, 'cause we have our viewers, is, you know, when there's fill dirt that's put in without the proper, you know, there could be drainage issues, there could be other issues, so. I'll assume that a factual basis exists based on the fact that we're not contesting it as a violation and assess a one-time $3,000 fine. Okay, is there anything else? Actually, I'll also allow, is there anyone from the public who wants to be heard on this case? I don't see anybody, so is there anything else you want to put on the record?
No, I'm fine.
All right, thank you, sir.
Next case is Haines Central Florida Business Services, case number CE 2025-623, CE 2025-648, pages 20 and 21 of your agenda. Expert on the case, Joanna Coutu, Land Development Director.
Good morning. Can you raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
And they
Good
are
morning,
not
sir.
contesting, sir.
I'm sorry?
They're not contesting.
And I was going to get to that. This is a no contest as well. Both parties have agreed to 60 days for both violations and $100 a day thereafter if it's not abated within 60 days on both violations.
Sir, can I ask you for your name?
Alan Haynes.
Alan Haynes. And so you are the owner of Haines Central Florida Business Services? What does that company do?
We do commercial cleaning and also have some properties that I rent out.
Okay, great. So is the resolution that you just heard on the record accurate? You've agreed to resolve both of the pending cases in 60 days, and you're going to get that done?
Yes, absolutely.
Okay.
We're going through an eviction process at the moment, which is delaying things, but we've been working with the code compliance officer, and 60 days should be okay to
Okay.
get that done.
And what they've agreed to do is say that, you know, if it's not brought into compliance within 60 days, there'd be a $100 a day fine. Now, that's almost as low as the county is willing to go, just so you know. So, you know, we have authority to do up to $1,000 a day, so that's a real reasonable resolution. And I will assume that a factual basis exists based on the fact you're not contesting the cases.
Yeah.
Okay.
There's no
Right.
contest at all.
I get it. Is there anyone from the public who wants to be heard on either of these cases? I don't see anybody, so those will be my orders. I'll issue them in writing, and I hope you have a good day.
Okay,
Thank you.
You too.
Thank you.
Next two cases, Linda D., Rodney T. Snipes, case number CE 2025-675, CE 2025-677, Code Officer Cody McGuire, pages 30 and 31 of your agenda.
Sir, can you raise your right hand? Do you swear to tell the truth?
No contest on this one as well.
And these are on two cases?
Yes, Your Honor. I've been advised $200 a day thereafter.
Sir, can I ask you to state your name, please?
Sean Snipes.
Sean Snipes. And you are one of the owners of the property?
Yes.
Mr. Sean Owen Snipes? Okay, gotcha. Did you hear the terms of the resolution
Yes.
that were put on the record, and you've agreed to that?
Yeah.
Okay, so I'm gonna assume that there's no issue there, that there's a factual basis for the violation in each case, and you would have 30 days in each case to resolve them. I see that it's an unlicensed and inoperable junk vehicle case. I see that there's a junk debris case, and if it's not brought into compliance as ordered, $200 a day.
Yeah.
Okay? And I'm gonna issue a written order for each of the cases, because that'll be what it is for each case, right? So theoretically, if it's not brought in compliance in 30 days on either of the cases, it'd be a fine running on each case. Does that make sense?
Yeah.
Okay. Do you have any questions for me?
No.
Is there anyone from the public who wants to be heard on either of these cases? I don't see anybody, so Mr. Snipes, thank you for your time. That's it.
All right.
All right.
Thank you.
Next case, Holiday Builders, Inc., case number 2025-509, Code Officer Julie Wilkinson, page 26 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
I do.
Yes.
That this is a no contest as well, that the parties have agreed to a one-time fine of $2,500.
Okay. Good morning, sir. What is your name?
Justin Boucher.
And are you the owner of Holiday Builders, Inc.?
Director of Construction.
Okay, got it. And have you heard the term of the resolution here, correct?
Yes.
Do you argue, do you contest that?
No.
Okay. Do you contest that there's a violation on the property?
No.
Can you just tell me a little bit, Ms. Wilkinson, about what it was?
Yeah, it was a vacant lot that they had cleared and graded and brought in dirt.
Okay. So is there anyone from the public who wants to be heard on this case? All right, I've already talked about the issues that are involved with this kind of thing. So, Mr. Boucher, what I'm going to do is issue a one-time $2,500 fine. And which, again, just for the record, we've already heard a $3,000 fine on the record here. $2,500 is, I don't think I've heard the county ever recommend a lower fine. So like this is what we call a plea deal, you know. So I appreciate your time. I'm going to issue a written order to that effect.
Yes, sir.
Thank you.
Next two cases, Jose Giovanni Galarza Castro Villafane and Sheila Michelle Rodriguez, case numbers 2025-370 and 2025-453, Code Officer Erica Olson, pages 18 and 19 of your agenda. Expert on the case, Joanna Coutu.
Good morning. You raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Good
Your
morning,
Honor,
sir.
I've been notified this is also a no contest case. For a case that ends in 370, a no contest plea with 90 days to abate and $150 a day thereafter. In case that ends in 453, a no contest plea with a one-time fine of $3,000.
Sir, can I ask you to state your name, please?
Jose Villafane?
Okay. And you are one of the owners of the property?
Yes, sir.
Okay. Can you tell me a little bit about what the county's case is?
Yes, sir. So the first case, the one that ends in 370, is a violation of Land Development Code Section 2412, General Commercial District. Essentially, they have a junkyard in the back of the property, and it's not zoned to be like a salvage yard.
Okay. So you're asking for that to be corrected?
Yes.
Okay. And the other case?
The other case is the site mod. In the back of that property, they took down, a lot of trees. The property is 1.9 acres.
Okay. What is the, Mr. Villafane, I'll ask you, what is the property otherwise used for? Is it used for anything else besides?
I mean, I have a towing company. And,
Gotcha.
a towing company as well. It's an auto repair.
Yep.
So, like I said, you use it for that. And
Okay.
Some of those cars.
That makes perfect sense. All right, have you heard the terms of the resolution that were announced by Ms. Harrison?
Yes, sir.
So on case number 25-370, which I'm going to call the junkyard case. It's 90 days to abate that violation, to get that stuff out of there. And if it's not brought into compliance, $150 a day. In case number 25-453, which I guess is the removal of the trees case, it'd be a one-time fine of $3,000, which again is very low on the county scale. And you've agreed to that.
Yes, sir.
Is there anyone from the public who wants to be heard on either of these cases? All right, then, sir, thank you for your time. I'm going to issue written orders to that effect. Thank you.
Appreciate it.
Okay, well, it's a very high percentage of resolved cases, so good work to the county.
Next case, Brian and Shalissa Berry, case number 2025-455, Code Officer Alan Jonason, page 5 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
I do.
I do.
All right, and sir, may I ask your name?
Brian Barry?
Okay, and ma'am?
Shalisa Berry.
Okay, and I didn't notice, but did you both swear an oath?
Yes.
Okay, great. Good morning. All right, what's the county's case?
Alan Jonason, Citrus County Code Compliance Officer. This is case number 2025-00455, Citrus County Land Development Code, Section 4002, site development without a development order or permit. The address of the violation is 7851 East Smoke Trail, Inverness, Florida. Property owners are Barry Bryan and Barry Shalisa. I hope I said that right. This property is 0.29 acres and is zoned CLR MH and was purchased on 15 September 2022. I have good service via signed certified mail receipt and posting at the Lecanto Government Building. I'd like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 1 April 2025, and an aerial photo from the property appraiser's website from 7 May 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the signed certified mail receipt, and a copy of the pre-hearing order.
And so one thing before we show the photos is I guess I'm just going to ask for a narrative. I'm going to start doing this. What's the narrative of the case? Like what's happening?
So site mod, they remove trees and
It's a
graded
tree
the property.
removal
Yes, sir.
case. Okay.
Well, no, it's modification as well. There's been grading done.
Okay. Well then, sir and ma'am, I'd like to ask you to take a look at these documents that they want to introduce as evidence and let me know if you have objections to them being evidence.
That's all I could. Those are all the letters that you need. Okay, yeah, all good.
Okay, so you don't have any legal objections to me seeing these as evidence?
No.
Okay, thank you. Now, do you all have evidence
Yes,
as
we
well?
do.
Okay. Thank you. All right, so without objection, what's been proposed as Exhibits A and B are evidence, and I'll ask Mr. Jonason to proceed.
On 1 April 2025, I conducted my initial inspection and observed the property to be in violation. On 1 April 2025, a notice of violation was issued for site development without a development order or permit, which is a violation of the ordinance I mentioned earlier. On 1 May 2025, I conducted research with no permits issued, and as of my final inspection on 17 June, the property remains in violation, and I have had contact with the property owner. Land Development Director Joanna Coutu is the expert witness.
Okay.
Good morning.
Good morning.
Nothing much to add. It is a
Did you
residential
swear an
lot.
oath, Ms. Coutu?
I did very
Okay.
first application.
Okay, just making sure.
Yeah, you're fine. Residential lot vacant as of Monday of this week. There were no building permit applications for the site.
Okay, and have you had contact with the owner?
have
at
not.
all? All right. Mr. Judson, what's been your contact?
We briefly spoke on the phone that he indicated that he just cleared some brush and stuff off the property. But after looking at the aerial and what was done on the property, it's a little more than that. Just towards the front of the property, like all of the trees removed at the very front.
Okay, all right. Well then, Mr. Berry, I'd love to hear from y'all.
Okay. Number one, there's no site development. This property was cleared because I would have been in violation of nuisance code 20-30 because of the overgrowth, the down trees, the trash, garbage, and other debris that was there, carpet, and so on and so forth, which I have documentation of. So I'd like to
So,
submit.
so what you're saying is that there was a good reason to take things off the property, which was that there was basically a nuisance condition.
Absolutely. And I have pictures showing all this.
Well, and I want to see those, but have you explained that to Mr. Jonason?
I did, and tried to meet up with him to give him these pictures of previous and the property work that was done.
Okay.
And he said the best move moving forward was just to let it run its course and be here today.
Okay. Well, let me ask you this. So before I get to the photos, sometimes
Okay.
it helps me just to know the narrative. There is a picture from the property appraiser aerial, and it does look like there were more trees in the aerial in 2024 than there are now.
Absolutely.
So that's accurate.
Yep.
So what happened to convert the picture from the property appraiser website to the way it is today?
When you see these pictures, you'll understand more of the potato vine growth and whatnot. And Hurricane Milton took out 2 of the good trees that were on the property, which I have shown laying on the ground, root bases exposed. And then in order to, when you see how thick the property was, when you see these pictures, you'll understand of the extent that we had to go to get the property cleared. And then I have current pictures of what the property looks like.
Okay, well, let's go through your pictures and I'll give you a chance to explain. I want to know if the county has any objection to them.
Excuse me. May
Go
I
ahead.
speak? On the back of each one, I do have picture angles and what you're looking at, in case, because they are cluttered as far as the pictures themselves, the debris. It'll tell you what you're actually looking at.
Are there dates on the photos?
I don't think
Can
so.
you represent around what time you took the photos?
From phone records, I could probably research that. Yeah.
Well, do you have a ballpark estimation? I mean, was it back in 2024? Was it in 2025?
This, yeah, that would have been towards the end of 2024, after the storms.
Okay.
Yep.
And which one of you took the photos, or both of you, or?
I did.
You did, okay.
There are 2 photos of
That's the trash that I removed, the trash and debris that I removed from the lot that you can't see because it was so covered up. In one of those pictures, you can see some of the tires and stuff that were under the oak trees. But in that trailer, you can see all the trash debris removed.
The county's not sure as to relevance of those 2 photos. Other than that, we have no objection with the photos.
All right, and I'm admitting these photos as Exhibit C, and I'm just going to take a quick look through them. And I'll let you explain, but I just want to look through.
Okay.
Mr. Berry, is it your testimony that on those 2 pictures we were just talking about, that was debris that was kind of on the property?
Trash and debris.
Trash.
Correct. Yes.
And how did it get there?
I would assume previous neighbors used that lot as their trash burn site.
Okay, and so it's your argument or position that leaving that would be a violation of our code anyways, because it's junk
Absolutely.
and debris?
Correct.
Okay. I agree with that. I will say, I mean, I guess I agree with Ms. Harrison insofar as I don't think these, while I understand your position on that, it doesn't have to do with the development part of it.
It
The
just-
site development part of it, which is
Well,
really the trees.
where there is no development because we're not doing anything with the property. It was literally all based back on the nuisance code 20-30, being obligated to clean the property and
That's
rid it of
true,
that.
that's true, but and that includes accumulations of vegetative matter as well.
Right.
So that's what I'm gonna be focused on, not the tires and things like that, because I agree that had to go, but they're not bringing a case for that.
Okay.
And when they say site development, the way that really works, it's basically any material change that gets made to the site. So it could be, it's not necessarily taking down any tree. So if it's taking down one very thin, small tree, or sapling or seedling, that's not considered site development in Citrus County. Grading is, taking out large trees is, and I see what you're saying about, I do definitely see some Milton issues here. But I'm still going through the photos, and I think the real test is all of it, Milton, or is some of it not Milton? That's what I'm trying to understand. Let me ask you about, because it's not a huge piece, right? It's 0.29 acres?
Correct.
Okay. I'm showing, I don't know if you can see, it's you've labeled it current photo from road and center of lot. So
Correct.
center of lot is behind the fence?
No, I'm standing in the road in the easement, shooting the whole property at that point.
Okay, so where's the property line? Is it in front of the fence?
The fence is the property line.
The fence is the property line?
Yeah.
Okay, that's what
That's easement up to the fence.
gotcha, that's what I want to know. And, okay. Can the county, based on its photos, which do look different, I mean, the photos do look different. I'm kind of curious about that. In the county's photos, it seems like it's a lot of, just looks more barren,
Before the grass grew in, you mean?
I think that's accurate, yeah.
It's been 2 months.
That's right. This was taken on April 1st, and that was before
Yeah.
some of it came back. Can the county rule out Milton's effect? And, I mean, what's the county's position on that?
In my professional opinion, I think possibly the lot was developed for future use or sale or something, I'm not for sure, but I cannot testify that
And Your Honor, we would argue that the tree coming down, it looks like one, maybe two in respondent's photographs. If he wants to clean that up, okay. If he wants to take care of the potato vine, okay. Maintaining your property does not mean you clear cut the property, does not mean you grade the property, doesn't mean you take it down to the dirt and start from nothing and develop the site. So while we appreciate in the fact that he was trying to be in compliance with code 20-30 as he references, there are a lot of ways to be in compliance with 20-30 without violating LDC 4002A, which he's done in this case. We believe he's gone beyond cleaning up after Milton and maintaining his property from potato vines and gone straight into site development with the clearing and the grading.
Is the county's position that removing potato vines is not impermissible activity? I'll tell you, I don't think it's impermissible. I mean,
Right, so we define a tree as 4 inches in diameter. So
right.
it's not really a tree, but you shouldn't have to take a tree out to take those out.
So what about bushes? What about, take this first photo, for example.
Right.
There's a lot of various shrubbery type.
I would say that definitely is a material change if you remove those big bushes, absolutely. I mean, if you want to develop, of course you don't want invasive stuff, but.
What if it was just one bush? I'm serious. We need to, I mean, what if
Right.
it was just one bush?
I think we'd have to look at it overall. If it was one bush and we were bringing one bush before you, then you probably have a good argument, but I think this is more than that.
And I think it'd be different if you mow the bush, like bush hogging, where you don't disturb the land, you don't disturb the way the grading in the ground, versus going in and ripping the bush out, disturbing the land, and you have to grade and go from there.
Correct.
What kind of grading have you done on the property?
I used a little skid steer to smooth the property
How
out.
little? I mean, help me understand.
It's got a 5-foot blade on it. I don't know the actual size of
Okay.
the skid steer.
All right. In,
May I?
yeah, well, what
Okay.
would you like
In
to say?
some of those pictures, when you guys said that, ripping everything out from the ground and this, that, and other, when you look at the intertwined vines on those trees that were toppled over and on the ground, there's no way of removing that stuff without removing all of those vines. And those vines are an intrusive vine. And number two, in some of those pictures, you can see where I did not go property line to property line. There is grass on down both sides where the property was not touched. I did not develop or impede on anything that was not in the way. And on the backside of the property, you can see that big mound of growth which harbored all of the trash and debris that was inside of that. There's no way to remove that without breaking dirt.
This is for the benefit of everyone. There's a lot of different kinds of cases that come here at Citrus County Code Compliance. And one of the types of cases is a junk type case. This isn't one of those cases, but something like that, you could have like wildly overgrown grass. You could have, old appliances strewn in the yard. That you know what I'm talking about because you've probably seen these properties. And I have a scale of 1 to 10 that I like to talk about. So when I get a junk case, if I see, just some junk in the yard, that might be a 3. Not so bad, but still a violation of the law. A 1 might be, there's just a little bit of junk out there, but, it's a violation. This is, I'm going to have to create a scale for site development stuff of 1 to 10. I think that what has happened on the trees, when I compare to the property appraiser picture, which I think is good evidence, I do think that there's a lot of, I think there's more than just 2 trees that have been removed, right? It's not just 2 trees that fell down.
No, there was only 2 trees that fell down. Correct,
Okay.
That were cleaned up.
And those are the only 2 that were removed?
Yeah, other than the shrubs and brush.
Okay, right, okay, right. And I think a lot of this aerial, there's actually several trees still there. It's just hard to tell from the county's photos because it's of the time that it was taken. There aren't,
I've got a dead oak tree on the property right now I didn't take down because I didn't want it gone.
right. I also don't know that, I definitely think some of the clearing will make it easier for development, but I also don't really know how you get rid of that vine stuff without taking down some of the bushes. It doesn't seem fair that you'd have to compel a property owner to keep all the nasty stuff that kills other stuff without a permit. But I think that this is site development, Mr. Berry, because of the grading. I know how that's going to sound to you.
Now, when you say grading, I'm
Yeah.
not allowed to maintain the property because the only grading necessary was the damage done caused by the tractor and the tree removal. Root bases, they come out. You're supposed to just leave them there to create mosquito dens?
Yeah, I really do understand your point, but what they're saying is if we look at the code section, for example, and this is everything you have to comply with. These are all the rules, okay?
I did not read all of that.
I haven't. It says, no development allowed by this code shall be established, changed, or altered, and no building shall be used, occupied, or altered after the effective date of this code until there is first on file, approved by official county action, a site development plan, et cetera, et cetera. Nothing herein shall relieve any applicant of the additional responsibility of seeking all permits required by any applicable statute, ordinance, or regulation in compliance with all the terms of this code or any other applicable law. A site development plan shall be required for any development on vacant land. And then when you look at what this section talks about is it's everything. We go to section 4100. A site improvement plan shall be required for any development proposed on improved land. removing you're definitely allowed to remove fallen trees. And I agree that you had a nuisance condition that had to be fixed. But the amount of change on the property, I mean, I'm not happy about it, to be honest. But it looks to me that it does just cross the threshold, but I'll get to it. Let me ask, is there anyone from the public who wants to be heard on this case? Is there anything else from the county?
No, sir.
Is there any?
I have something to say. I have one thing to say. I can't stay quiet about it. I know there's a thing.
Yes,
Up to the
sir,
mic.
if you do want to be heard, you need to,
Stand up.
you need to come up, identify yourself.
Gordon Lilly. Yes. I do. I'm just kind of curious about one thing about this. You know, you're talking about.
You said your name,
removing-
I'm sorry, the county
Gordon
attorney
Lilly,
didn't hear your
Gordon
name.
Lilly,
Yep,
Gordon Eugene Lilly.
thanks.
Yeah, I was just wondering, because this pertains to, I know you have to have a certain amount of trees on a piece property or whatever, but I understand the site development and everything like that. But what if the gentleman actually puts trees back onto the property? Because you're saying basically it's about him removing it and, you know, going with a different situation, going in a different direction, like selling or whatever. What if he puts trees back onto the property? Will that put him back into a situation where it's, because it sounds like to me it was all created by trees, and he's saying about the trees being removed. Well, what about if he puts trees back on the property?
Thank you.
Would that be a nice thing? Because I know there's so many trees have to be on a property if you're removing trees from the property.
There's a lot of rules with that, but thank you, I appreciate that. That's a question, a very, very good question that's come up a lot at our hearings on this kind of thing. I'm gonna find that there is a violation and assess a fine of $200.
Thank you.
That's the lowest fine ever recorded on one of these cases. The reason why is that I think it just crosses the line, unfortunately, due to I understand your position that it's grading based on the stuff you had to do. But I am convinced that the amount of stuff was taken was probably more than needed to. So you can appeal my orders, okay?
Okay, so what does this mean moving forward?
You've got a fine of $200.
And then case closed?
Correct.
Okay,
All right, thank you.
all right. Are those mine or yours?
Well, they're evidence now.
Okay.
Yeah, you can get copies of them, yeah, yeah.
Thank you.
Thank you.
How do I proceed? Where do I go?
I'll issue a written order, and I encourage you to talk to the county.
Okay.
Thanks.
Next case, Gordon Breyer Jr., case number 2025-542. Code Officer Erica Olson, page 10 of your agenda.
I do.
Good morning.
Morning.
I already have the gentleman to the right's name and sir to the left.
Yes, my name is Gordon Breyer Jr.
Okay, thank you, sir. Please proceed.
Good morning.
Good morning.
Erica Olson, Citrus County Code Compliance Officer. This is case number CE 2025-00542, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20, TAC 31 Alpha of the Citrus County Code of Ordinances. The address is 5290 South Memorial Drive, Homosassa, Florida. It's 0.20 acres and zoned RUR. Property owner is Gordon Breyer Jr. I've got good service via posting the notice of hearing on the property and posting at the Lecanto Government Building. At this time, I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 22 April 2025, corrective action inspection 7 May 25, photos from my inspection on 05 June 25, and photos of my final inspection conducted on the 16th of June 2025. Exhibit B, a photo of the notice of violation, a notice of hearing, the copy, I'm sorry, hold on. I have a typo. Copy of the general pre-hearing order, a copy of my posting affidavit and a copy of the notice of hearing post on the
Now,
property.
before we get to that, I just want to make sure, are y'all contesting whether or not there's a violation on the property?
There is not now.
I'm not trying to twist your
Except-
arms.
Yeah,
No,
I'm-
there's one thing on the property, which I do have a signed statement saying that it's going to be taken care of.
Okay. I mean, normally what happens on this type of a case is even if we all agree that there's a violation, I have to give you an amount of time to comply.
Okay.
It's already
Which is why I'm not sure
And-
if you all agree that you just need a little time to
Done.
fix.
Except for this one thing.
Okay, there's one thing. and
Yes.
Ms. Olson, are you aware of this, whatever this one thing is?
When I went out there on Monday, I mean, it is almost cleaned up. There was just a couple totes and like a moving box. They do have a roll-off.
What's the one thing there's a problem with? Just tell me what
The one
that,
thing is I don't know, whether, yeah, but anyway, it's a shed. Okay.
That's
we-
not part of my case.
it's not part of the case.
Okay.
And hey, you know,
Well,
what
That's
they
what's
say in criminal
building.
cases, maybe you shouldn't take the stand.
Well, it's not
You
a
don't have to
problem.
volunteer that there's other violations on the property. I assure you, you don't have to do that.
Okay. Well, I
This
just
is
wanted
just-
to let you know, sir, that we are taking care of it.
Well, look,
Okay?
how much time do you need to bring the property into
We
compliance?
already
Done.
did. It's done. We have the pictures.
Okay, so if I said 7 days, and county could go and re-inspect, was it still in violation on your last inspection?
Yes, on Monday, there was just
A little
a few things,
Okay.
so, and I can see maybe what.
Okay,
could be a
sure, yeah,
violation.
if the county's inclined to take a look, yeah.
Wanna look at that?
When were the photos taken that you're showing?
Yesterday and the day before, Tuesday
Okay.
and, well, no, Monday afternoon and then Tuesday.
We'll see if that resolves it with the county.
Well, like I said, we're in the, about the totes and stuff like that. I
We did
mean,
a lot of work.
we did.
Yeah.
I still had the tip there too, so, I mean.
Well, I get it. It's hot out there.
It was very hot out there.
Your Honor, we would request the 7 days, just there's a small portion of the yard that's not in the photographs, just so we
They
can
want
walk,
to be
look
able
at
to
it.
re-inspect to ensure that the violation
Oh,
that
not
they've
a problem.
documented. Okay, so what's the county's recommendation if it's not brought in compliance within, say, 10 days?
$50 a day.
All right, that's the lowest they've ever gone.
Okay.
All right,
It's
so,
not a problem.
so
You can
here's what
come
I'm
out and
inclined to
take a
do.
look if you want to.
So I just want you to hear this. So what I'm gonna do is, I will find that there is a violation based on the county evidence, but I'm gonna grant you 10 days to bring it into compliance.
Okay.
And if it's not brought in compliance within 10 days, there'll be a $50 a day fine.
Okay.
I think it might already be done.
Yes, sir.
But just they need to come out and take a look.
Okay, that's fine.
I do have a question.
Yeah.
Before we leave, what is in that we still need to do? Because
Yeah,
I need to
that's-
verify that before
What
we
was
leave.
left?
Okay.
What was left on
It
Monday?
was really just a few totes and some boxes. Based on the photos that they just showed me, I don't see anything, but there is part of the yard that's not in the photos.
Right.
I can be out there probably later this week if you want to meet me out at the property, and
In other
then
words, there's nothing that wouldn't take literally an hour to fix.
probably less than an
Right,
hour, to be
so-
honest.
I'm gonna grant you 10 days, $50 a day if it's not brought in 10 days.
Okay.
Is that good?
Yeah.
Well,
Is there anyone from the public who wants to be heard on this case? Sir?
I just have to say one thing.
Yeah.
I know that it wasn't brought up in it, this particular issue, and I'm not gonna say nothing. This doesn't pertain to could be found that she's not seeing, right? I'm just saying, because this here,
I'm not here to talk about that. I understand what
I
you're
just don't
saying.
wanna come back, because
Look,
it's gonna be taken care of.
If she finds a
so-
dead body on the property, she's gonna call 911, you know? I mean,
Yeah.
so I don't know what's gonna happen on the inspection. She's there for I'm not
JC?
accusing you.
I just want a
I'm not
chance to
accusing you,
strike it. I
But
just hate to come
I
back
can't,
and,
I'm not gonna
you know.
compel her to close her
Right.
eyes to
Okay.
anything else.
Okay.
She's gonna
all
be
right,
out there
just
on a
what
junk
she
case.
needs right now, currently.
Okay? That's
All right,
it.
Sounds good.
Thank you.
Okay.
Thank you, guys.
Okay.
Good luck on that inspection.
Next two cases, Kenneth Casanova and Robert Rada, cases 2025-498 and 2025-499. Code Officer Cody McGuire, pages 11 and 12 of your agenda. Expert on the case, Joanna Coutu.
Now, you're bringing them both at the same time. They're listed under different addresses.
Are they listed on the-
Now, I don't mind that, but I don't know if you want to separate them or not.
We'll separate them. We'll do case number 498 first, Cody.
Okay.
Page 12 of your agenda.
Can you raise your right hand? you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
And ma'am, what is your name?
My name is Kaylee Casanova. I'm the wife of Kenneth Casanova.
Okay. Are you an owner of the property? Either of the properties?
I'm not on the deed, but it was just my husband and my grandfather.
Okay. Do you live on any of the?
live, yes,
Okay,
I
that's
do.
fine. All right, please proceed.
All right. Cody McGuire, Citrus County Code Compliance Officer. Case number 202500498, a violation of Citrus County Land Development Code, Section 4002, site development without a development order or permit. Address is 10340 West Palmendeo Circle. It's 0.82 acres and it's zoned RURMH. The property owner is Kenneth Casanova and Robert Rada. Good service via posting at the property and posting at the Lecanto Government Building. I'd like to authenticate the following documents and request they be admitted in evidence. Exhibit A, photos taken during initial inspection on April 3rd, 2025. Corrective action inspection on June 22nd, 2025. A pre-hearing inspection on July 14th, 2025. Aerial photos and a flood map. Exhibit B is a copy of the notice of violation, copy of notice of hearing, copy of the posting affidavit, photo of the property posted, and a general pre-hearing order.
Now, before we get to that, so this is a no development type case. Are y'all contesting whether or not there's a violation on the property?
No.
Okay. What is the county's recommendation on this case?
A one-time fine of $5,000.
I would like to see the photos. So can you show the photos to, is it Ms. Casanova?
Yes.
Okay. Let me know if you have any objections to them for this hearing.
It's almost like the same picture, just a little
Yes.
further over.
And then,
Like
yeah,
from the left
that's
side of
not
it.
there anymore.
No, it's just
Oh.
showing the lot.
Okay, yes.
Yeah. And that's on a different date.
Yeah,
That was on one.
the other day, yes.
And then the rest of it is all of the legal paperwork. So that would have been the violation. That's
While
the
we're waiting, is there
property
anyone
that's
for
in
the
ground.
public who wants to be heard on this
Your
case?
kids
Okay, thank you.
probably playing hide and seek.
Oh, yeah, yeah. That's it, that's right here.
And then those are just photos of me putting it in the ground.
Okay. Thank you.
Do you have any objection to these being evidence?
I know.
Okay. Okay. All right, thank you. Then without objection, what's been proposed as Exhibits A and B are evidence. Now, the violation itself isn't being contested, so I don't think I'm going to receive any evidence today that suggests it isn't a violation. I'm looking at the photos. I can see where the county's going. How big is the property?
0.82 acres.
22?
No, 0.82.
Oh, 0.82, okay. Is that a trampoline?
Yes.
That's a good use of, property, so that's good. That could be a couple bucks off the fine. Mr. McGuire, have you had any contact with the owners before today, or?
Yes, sir, I
tenants?
have.
Okay, and
Her husband had actually called me whenever the kids found my posting on the property.
so have they indicated, what did they tell you?
It was not with intentions of doing this. It started out with moving damaged trees from storm debris and then clearing the property for the kids to play and ride
Okay.
bikes and stuff.
Okay. Have you heard anything you disagree with, ma'am?
No.
All right. I would like to hear from the public. Sir, you indicated you wanted to be heard. You might want to come where the county podium is, over here. Sir, can you tell me your name?
Craig Compton.
Okay, thank
I am
you.
the current president of the Spring Run Property Owners Association, representing. Our concern is that's a flood area. We've got a lot of flood area in that area. We're trying to determine if it was wetlands. When we approached Mr. Casanova, when he was starting this process, it was just going to be clearing a few trees, the stuff out. And all of a sudden it's got blown up. We've contacted him and discussed it with him. He assured us the county was involved and had approved this. Said he didn't need permitting for it. We have since found him in our violation of our covenants for this, which has nothing to do with y'all. But we're concerned with the amount of trees and stuff that was removed. What's going to happen with all that water now? We'd like to see some sort of a engineering study done as to what removing all those trees is going to do to the flow of the water in our neighborhood. So that's
I
our
appreciate-
concern.
all right,
Because
well, thank you for your-
Unfortunately, the trees are gone, they can't be put back. We
Right.
wish some could be put back in there to keep the erosion, but
Trees can always be planted. I mean,
but that's not something y'all would mandate.
I can't.
Right, that's what I'm
That's
saying.
beyond my authority.
Yeah, so that's our concern is where's
As
that-
is requiring
where's the water
engineering.
gonna go? That was, those trees did suck up water and everything else, so what's gonna happen to all that water now?
Gotcha.
We've got, completely undeveloped areas out there.
Thank you for your input. All right, is there anything else from the county?
No.
Okay. Ma'am, is there anything else you'd like to
Yes,
say?
I wanted to add, my husband has been in contact with Anthony Vixeo with the DOP regarding moving the dirt, that there was a big mound there, removing that, and laying seed, also planting up to 10 trees was something that we did talk about, if that would help.
I mean, I definitely going to find that there's a violation. The question is just the amount of the fine. That's really my authority. I can't compel y'all. I don't think I can compel anything beyond that, essentially, for a case like this. In certain cases, I may have authority to kind of enjoin things or issue injunctions, but here it's already been done, so. What I'm going to do is, based on the evidence, I'll issue a fine of $3,500. I'm not going to do the $5,000, but I do think that based on the testimony and the size of the lot, and the amount of the work, that there does have to be a deterrent effect.
Sure.
All our viewers will see, but that's it. So I appreciate it.
Okay, thank you.
Now, I think you have one other case.
Oh, okay.
This is case number 499, and it's page 11 of your agenda.
Page 11.
11, yeah.
Next case.
Okay, and this is gonna be the same scenario, just the next lot over to the right.
It's the next lot over, so is that a smaller lot?
I believe it was 0.82, but I might have a Scrivener's error on there.
Ma'am, do you know what the size of these lots are? Okay,
No.
okay,
That's pretty close, sir.
okay. Can I see the photos? Sure. And can you show them to Ms. Casanova first?
Yeah, that was last, or this week. Okay,
And then that was the same notices as
thank you.
You're welcome. Thank you. They're both the same size? Are both lots the same size?
They bought all 3 lots together, so the PA has at 2.88 acres.
Oh, I see.
And so I'm not sure exactly what the breakdown is. The PA is not giving it to me.
I see. Well, that makes a lot more sense, because that looked like a lot more than 0.82 or, okay,
And the house is developed on one of them, so it's the other 2 lots that
Okay.
were at issue.
got it.
I actually think I got from the GIS, it was 1.3 for this one and 0.8 for the other one. That's about 2.1, and then the third lot would go up to about 2 point, what are they saying? 2.8, that's probably about more accurate, 1.3
Okay.
for the second one.
All right. Is there any other additional testimony or evidence that the parties want to give on this case? I'll assume it's the same. Okay. Anyone from the public want to be heard? Nope. You reiterate your, okay. I'm going to find a violation and issue a fine of $1,500. That takes it up for both cases to $5,000. Okay? So, good luck.
Thank you.
Thanks. Thank you.
Next case, Douglas and Leslie Dalquist, case number 2025-521, Code Officer Julie Wilkinson, page 13 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Yes, sir.
All right, thank you and good morning. Can I hear what y'all's names are? What are y'all's names?
My name is Douglas Dahlquist Leslie.
Okay,
Dahlquist.
thank you.
We're one of the 10 Norwegians in Florida.
Yeah, well, is that number growing or is it getting smaller?
Well, I don't know. We're new immigrants. We've only been here for, the house is 2 years old in August.
Got it. Ma'am?
Julie Wilkinson, Citrus County Co-Compliance Officer. This is case number 2500521. Land Development Code Section 2405, Low Density Residential District. The address is 2556 North Pinecone Avenue in Lecanto, Florida. The property owner is Douglas and Leslie Dahlquist. I have good service via posting the notice of hearing at the property and at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Photos taken during an initial inspection on August 15th, 2025. Photos from a corrective action inspection on May 2nd, 2025. Photos of my final inspection conducted on June 17th, 2025. A screenshot of the property advertising for RV camping on the hipcamp.com website dated June 17th, 2025. And the Pinecone Acres page on hipcamp.com.
Okay, yeah, so sir and ma'am, can you take a look at these documents and let me know if you have objections to them being evidence in this hearing?
Where's that picture? Oh, it's from the front gate.
Ms. Wilkinson, while they're doing that, can you give me a narrative of what this case is about?
Yeah, so this case is about basically the zoning of this property. It's zoned low-density residential, which does not allow for camping on the property, and that's what they're doing. They're
You're
advertising.
saying there's like overnight camping?
Oh, for RV, for full hookup RV camping.
Okay,
Yes.
all right. Does that make sense what the county's case is?
They say, I guess, yes.
Are you guilty?
It depends on the definition of camping.
Okay.
An RV has refrigerators, stoves, heaters, air conditioners, toilets, showers. Like I said, we've been in the house since August, it'll be 2 years. That RV pad was on the building plans. They paid for the building permits, it was approved. It's all professional. I was told we're allowed to put an RV there, no problem, and so on and so forth. It comes down to the is an RV camping, or is it an alternative life? If they want to build a fire, I have a fire pit in the middle of the yard for them to use. They're not out there, it's not camping, it's an additional. Many people live in RVs year round. Now, there was a complaint from a neighbor, apparently. I haven't seen the complaint, but I haven't heard any complaints from any neighbors. I think what we're doing here is a win-win-win situation for everybody if I'm allowed to continue.
Then we'll get to that. Then
Okay.
I wanted to ask you quickly. I first have to let the county present. It's
Yeah,
because
that's
I don't
fine.
even know fully what they're doing. Do you have any objection to the documents that you've seen?
I don't.
Okay. So what I'm going to do is I'll have them admitted if you'd give them back to Ms. Wilkinson.
I'm sorry, I've got an injury and I'm hurting here.
Do you need to sit?
No, I can hang, if I fall down, you can pick me up and put me in a chair.
I'd rather not. Is there a microphone or something where if he can sit and...
Apparently, there's no wheelchair in this building.
Oh, okay, so we can take the microphone, if you need to sit down.
I'm fine. I've got
Okay.
here, please don't make me move anywhere else.
Okay, let the record reflect that you have chosen by your free will to stand no matter the pain. Okay, so exhibits A and B are admitted as evidence, and before you proceed, let me just look very quickly to see what you're talking about. How big is this property? Do you know?
4.49 acres.
It's completely
4.9.
fenced.
It does look that way. Let me just look through this.
It's a very nice, clean property.
It looks
I
like
hurt
it.
myself fixing it.
Oh, I agree. It does look nice. Let me take a look. You're a star host?
Pardon?
You are a star host.
Yes.
So people like going there.
Oh, yeah.
Oh, yeah, they love it.
Yep.
It's reasonably priced. We're in a great location to go spend money throughout Citrus County.
Really great hosts, peaceful and safe property, and the turkeys, dogs, and chickens were the best.
You should have turkeys.
Oh, I
Though
should.
They're.
I'd have all. The
She
county
won't let me
knows
have
I'd
a
have all
donkey.
these animals
Well,
if
she
I
won't let
could.
me
I
have
don't
an
know if you're
ostrich
allowed
either.
to, but let's see. Okay, so please proceed.
Yes. This property is a single-family residence, 4.9 acres, and is zoned low-density residential. On April 15th, 2025, I conducted an initial inspection and observed that an RV was on the property. I conducted research and found that the property is listed on hipcamp.com for full RV hookup camping on the residential property. On April 17th, 2025, a notice of violation was issued for a land use violation. On May 2nd, 2025, a corrective action inspection was conducted and the property remained in violation with the advertising on hipcamp.com. It's still up. I have had contact with Mr. Dahlquist, who wanted to know what the violation was, and I advised him that camping is not allowed on his residentially zoned district. I advised him that he needed to remove the advertisement and stop letting people camp on his property. He stated that he has reservations for his camping on his property up into the July 4th weekend. He also stated that it's one of the ways that he makes money. He also asked me if he could bribe me to make this go away. Not sure if he was serious or joking.
Come on now.
As of my final inspection on June 17th, 2025, the property remains in violation with the advertising remaining at hipcamp.com.
I do find that, you know, in American history, there's a grand old tradition of at least asking to bribe.
I didn't think extortion would work because I didn't know her good enough.
I'm joking. Okay, so what I'm doing is I'm looking at section 2405 in the Land Development Code. And just for the benefit, we'll get into it in detail, but among the things that it says is this category allows for residential development at a maximum of up to 2 dwelling units per acre. Higher density developments are allowed if you have a PUD, et cetera, et cetera. And then it talks about some of the uses that are allowed in the LDR district, single-family homes, accessory structures, a conditional use would be playgrounds, a permitted use is passive recreation, and that's all. So if it's not listed, then it's not allowed, and I think what the county's position is, county isn't here in the LDR table, but I'd love to hear from Ms. Katu if you have a perspective. Like, what is the basis for the RV being not allowed?
Right, so you're correct. Recreation or recreational vehicle park or two zoning districts would allow perhaps camping. They have to go through permitting, et cetera. Low density residential is very restricted, as you've talked about.
I mean, it's almost 5 acres. Is it common for, 4.9 acre parcels to be LDR?
It can be, yeah, absolutely. They could possibly subdivide. We haven't discussed that with him, but that would not give him the right to camp. That would give another house, which you can have an accessory dwelling unit anyway. I don't know if that's what they're pursuing, but it wouldn't allow
Is an
occupancy of an
RV
RV.
camping?
Well, you're not out of the woods. The answer to that question doesn't get you out of the woods, whether it goes your way or the other way, but we'll get to that. So is there any, what if it was more, because here's what I'm looking at. I see that up to 2 dwelling units are allowed. Under what circumstances is an RV a dwelling unit?
It's never a dwelling unit.
It can't.
It's temporary occupancy. It's defined in statutes and our land development code as a temporary occupancy up to 6 months in an approved campground. So the campgrounds have gone through all the permitting to be recognized, et cetera.
Right.
We can't have it in residential areas. It's not a actual dwelling unit.
So y'all strictly regulate that such that
Correct.
really there's only one place RVs can even be lived in.
Which is an approved permitted campground,
Okay.
yes.
Okay. is there any remedy, any type of conditional use or variance or something that gets him out of the woods on this?
Not for
Given the zoning?
Yeah, not for camping in an RV. I mean, we have the 2 weeks a year for guests to come stay.
Right.
That's it. There's not anything that would allow that in LDR, no.
What abates this?
Removal, stopping the, he's correct, in an RV, you can own an RV. You just can't occupy, you certainly can't rent it out. So what would abate it is stopping the rental, stopping the advertisements, stopping the rentals. He wants to park an RV on his lot, he can do so. If there might be deed restrictions, that's not something I know about, but camping there can't happen.
Thank you. So, and by the way, you can cross-examine any of the county's witnesses as well, but here's what I'm going to say is I don't think that while your question about camping is actually academically interesting and philosophically interesting, it's not determinative of this case. And the reason is that I'm going to show you a piece of paper. On this piece of paper, it lists all the permitted and conditional uses you can have on this property. If it's got a P by it, it's allowed, okay, no questions asked. If it's got a C, you got to get permission still, but at least you could get that. There's not many Ps. One of them is single-family homes, so that's fine. You've qualified for that. But then there's accessory structure like a shed, something like that's not what we're talking about. Well fields, we're not talking about that. Utility facilities, we're not talking about that. We're just, there's nothing else in here that gets you out in terms of allowing this use that you use it for, which is a rental, an RV rental. It's just not allowed on the property. Whether it's called camping or called something else, it's not in this box. Go ahead.
So we're at this point here and something new come out of the sky. We can't add another line on that sheet of piece of paper you there and allow this?
You can if you can convince the county commission.
I can't convince you and you convince him?
I don't write the law. See, that's the other thing. Judges are not supposed to be writing the law. I'm supposed to look at this and not think about politics.
I see that on YouTube all the time.
I'm not supposed to, I bet you have, but I'm not supposed to be reading, making up. I know that sounds crazy because
I'm going to follow whatever you say here. What's the bottom line? Do I got to pull things down? I've got a camper coming this weekend for 3 days, and I got someone coming from 4th of July for 3 days who lives down in Homosassa and wants to spend 3 days in my place. After that, I don't have anybody. Do I got to yank it? I can yank it. It cost me about 4 or 5.
I'm going to issue an order once I hear from the maybe I'll change my mind if I hear from the public, that gives you 30 days to bring the property into compliance. And if it's not brought into compliance as ordered, what will the county's fine recommendation be?
$200 a day.
There'll be a $200 a day fine if it's not brought into compliance within 30 days.
Can we change that to a 50-cent charge per day?
We could.
And then I pay them $200 a year, which is a good cut of what I'm making, kind of like a permit or something like that, and I can still keep being in business. And I can still make all the campers happy. They can come down here and spend thousands of dollars in the county and so forth. I can be happy, you can be happy. Everybody's happy.
If Citrus County wasn't better run, then you might be able to get away with that. But they do try to follow the code here. I try to follow the code. So the answer to that question is no. Are there any other members of the public who want to be heard on this case? Ma'am, please proceed. Yeah, come on up.
Move over. Who is it?
Well, no, ma'am, you can come to the county's podium.
Hello, my name is Idonna Davis, and I own the excuse me.
Raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
I'd love to hear from you, ma'am.
Yes, I'm the neighbor to the Dahlquist. We own the property adjacent to them. And most recently, our neighbor, who actually cited the issues, can't be here today because he had a leak in the kitchen this morning. The kitchen was flooded, so he called me and asked me to come in his place. Anyway, we don't have any idea who these people are that come and go. They're not vetted, number one. And we've had issues with this couple in the past for different violations that we've had to get an injunction to cease and desist for. So it butts right up to our property where his campsite is. He has repetitively violated our space multiple times to where the point I had to get a fence put in, and he even tried to attach to our fence, where we had to get that resolved by putting in another fence back on our property line, which he objected to, tried to take out stumps and all this other stuff. But anyway, we are not happy at all. There's other people in the neighborhood that are not happy. They haven't come forward because of the time element. We didn't know time or case number or any of that stuff until recently. So we're not happy at all that our community there in our neighborhood, which has low-density residential, I have 2.35 acres myself. The neighbors right next door, which they adjacent to, they're transient, or they live there, but they haven't objected, but they're not happy because of what's going on. And there's been multiple times when there's been trailers that have come in of over 40 feet or so that got stuck. There's a lot of racket noise in the area. It's right up to, it's like, this is our backyard, our corner's right here, and it's right there. So my main concern is vetting the people that come in. There's no vetting issues there. There's nothing to know that they're not terrorists or whoever, especially with this time element. So we're not happy.
Thank you, ma'am.
Thank you.
Is there anyone else from the public who wants to be heard on this case? All right, I'll give you a chance if you want to address that. I mean, you have that right.
Donna is the neighbor from hell. She's mad that I bought the 5 acres that she looked at for the last 20 years and she didn't buy it when it was for sale. I've been called, the police have been called for everything I've possibly done. I even had the turtle Nazis out there checking because I was supposedly murdering gopher tortoises. That's enough said.
Okay. Well, I do have to say it's a violation of the code, for better or for worse. If you want to do that, it's just going to have to be in a different zoning, you know? So.
The neighbor from hell won.
Well, I am going to issue an order to what I've already said with the fine amount, and we'll leave it there. All right?
Okay, I got 30 days so I can allow the person who's reserved here for 4th of July to come in.
I'm not making any, I'm just telling you it's got to be brought into compliance in 30 days.
Okay, so I'll take the advertisement down after, we won't reserve anymore and we'll be good to go.
Thank you.
Thank you.
Next case, James Head, case number 2025-470, Code Officer Erica Olson, page 22 of your agenda.
What page on the agenda? 22. Good morning. And sir, what is your name?
James Head.
Okay. All right, and are you contesting whether or not there's a violation on your property?
No, I don't know exactly what's going on with it.
You're not sure?
Yes, I'm not sure.
Okay, all right, then please proceed and we'll talk about it.
Erica Olson, Citrus County Code Compliance. This is case number CE 2025-00474, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20, TAC 31 Alpha of the Citrus County Code of Ordinances. The address is 6809 West Pershings Drive, Homosassa, Florida. Property owner is James Head. I have good service via certified mail return receipt and posting at the Lecanto government building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on the 26th of March 2025, my corrective action inspection on the 9th of April 2025, and my final inspection on the 16th of June 2025. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
All right, sir, I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence in this case.
Certified, they're certified mail. It came.
This stack. Sorry.
Some of that's fixed up. Where do you see?
We want to see who signed for that certified.
I'm sorry, ma'am?
Who signed for the certified mail?
It's just a signature. I personally don't know who signed for it.
Okay.
They just
I
put it
didn't
out
actually-
there.
We'll get into that. We'll get into
Okay.
that.
I was just curious about that because I didn't actually receive that.
That's all clean.
So with the windows and the doors, we got this all picked up now. I've been working at it.
Okay. Do you have any objection?
No, I don't think I have any objections. We've
Okay.
been working at, trying to clean it up since we became aware of, so there was a problem, so.
Did you was in jail when it first noticed?
Okay.
And then, and it's documented with the postmaster that his mom intercepts our mail and we don't get it. And I've reported that before this ever happened.
And ma'am, what is your name?
Samantha Couson.
Okay, and, well, that's fine. I mean, I don't, normally on these cases, I have to give a time to comply anyways. I'm not, no one's getting arrested for it not being done by today, you know?
I mean, the only way, when we found out about it, there was a stick, a piece of paper attached to a stick in the
Yep.
ditch by our mailbox.
I get
And
it.
when we found out about it and we started cleaning it, you know.
No, that's fine. So let me just take a look. Let's see. All right. Before you proceed, let me just take a look and.
Yes, sir.
Yeah, I mean, I definitely see attempts to improve it. Okay, so please proceed.
On the 26th of March, an initial inspection was conducted, and I did observe the property to be in violation of the above-mentioned ordinance. A notice of violation was issued. On the 9th of April, I conducted my corrective action, and the property did remain in violation. During this inspection, I did make contact with a man who said that he was the owner, but he did not give me his name. During my final inspection on the 16th of June, the property remains in violation. There's a couch on the porch, buckets, fencing materials, spare wood, and other miscellaneous items.
Okay. And to your question, the signature, there appears to be a printed name, S. Cusson, S-C-U-S-S-O-N. I don't, so, all right. It looks to me like there's still some stuff, but that it's a lot improved from
Yes.
what it started out as. So, I mean, how much time do you need to get it to the finish line?
I mean, it's all cleaned up.
Let's get a week or something, just
Yeah,
safe.
a week.
A week or so would probably be more than,
It's already cleaned up.
So
and
would
stuff.
14 days be
yeah, that'd be
enough?
more than enough, yes.
Okay. What's the county's recommendation?
$100 a day. plus
What is
administrative
it,
costs.
is there anyone from the public who wants to be heard on this case? All right, well, look, I appreciate that y'all have made efforts to substantially clean this. So I'll find that, yeah, there's a violation, but I'll give 14 days to bring it into compliance, and if it's not brought into compliance as ordered, $100 a day.
Okay,
Okay?
thank you.
Good luck.
Next case, Roberto Hernandez, case number CE 2025-582, Code Officer Alan Jonason, page 24 of your agenda.
I do.
Good morning, sir.
Morning, sir.
And can you put your name on the record?
Heriberto Hernandez.
Thank you.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 2025-00582, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. Address of the violation is 4381 East Trail X, Inverness, Florida. Property owner Hernandez Heriberto, 4381, 4393 East Trail X Land Trust, dated January 15th, 2025. This property is 0.51 acres.
Hey,
And
what
is-
was the date of that?
You really want me to go through that again?
No, just the date of the land trust.
Land Trust dated January 15th, 2025.
Okay, thank you.
Sorry about
No,
that.
No, that's interesting. Okay. It's a good idea. I like land trust. Go ahead.
Property is 5.51 acres, zoned rural mobile home, and was purchased 21 March 2025. I have good service via signed certified mail receipt and posting at the Lecanto Government Building. I'd like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 23 and 24 April 2025. photos from my compliance inspection on 27 May 2025, and photos from my final inspection conducted on 17 June 2025. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, copy of the signed certified receipt, mail receipt, and a copy of the pre-hearing order. Reason for the 2 dates: after I went out initially, I realized, I was doing more research, realized the property was larger than what I anticipated. I went out and took additional photos.
I see. Well, then, before we get to that, Mr. Hernandez, are you contesting whether or not there's a violation on the property?
I don't know if I'm actually contesting, but I have spoken to Officer Johnson.
So you're not sure?
I think I'm just looking for an extension, sir, because I purchased the property and I have an unlawful detainer, and I'm
Yeah,
using an attorney.
okay.
We have an eviction, we have a final hearing scheduled for a week from today.
Good. You can usually get
here-
those pretty quick, so that's good. Do you have any reason to disbelieve what he's
I
saying
do
about?
not. We've spoken on the phone.
Okay.
He indicated that.
How much time do you think you need?
So provided the final hearing goes and she gives me the writ of possession, I have somebody hired already so they'll execute, the sheriff's department will execute and they'll clean up that same day.
Normally, when you put property in a land trust, part of the point is putting it in a name that isn't obvious who the owner is. So it sounds like the name of your land trust is your name.
No, the name of the land trust is the address, and I'm.
Oh,
the
is
trust-
it?
and I'm-
Okay, then I misheard
and-
that.
and I'm the
But then
trustee.
why is it? Oh, because you're the trustee.
Yes, sir.
Gotcha. Okay, then, but you're not, but are you contesting whether there's a violation?
No, no,
Like,
absolutely not.
Okay, so that's what I'm
100%
trying to get at.
There's a violation.
So really,
yes, sir.
I just need to know, I mean, do you think, let's say that this person, the hearing goes well, writ of possession, person's gone. From that point, how much time does it take to clean this up?
Literally not that long, a week.
Okay.
But again,
Is-
it's all about the hearing.
I
That's why
understand.
I figure I just
understand.
request, I don't know.
But it looks
30,
like y'all are
60 days.
moving quickly.
I think so.
Is 30 days enough?
Can we go 60 just to be on the safe side?
Yeah, I would say there's a lot of stuff on this property.
Okay, then, what's the county's recommendation on a fine?
$150 per day plus administrative fees.
Is there anyone from the public who wants to be heard on this case? Look, since it's not contested that there's junk on the that there's an issue, I'll find that there's a violation, grant 60 days. If it's not brought into compliance in 60 days, there will be a daily fine of 150. But that should be enough time, even if this hearing
believe
doesn't
so.
go. Okay?
Thank you.
Thank you, sir. Appreciate it.
Next case, Jennifer Lee and David Allen Pearson, case number 2025-497, Code Officer Alan Jonason, page 29 of your agenda.
Good morning. Yes,
Good morning, ma'am.
good morning.
What is your name?
Jennifer Pearson.
Jennifer Lee Pearson?
Yes.
Okay, thank you.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 2025-00497, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. Address of the violation is 4822 North Tanglewood Avenue, Hernando, Florida. Property owner is Pearson Jennifer Lee and Pearson David Allen. Property is 1.17 acres and is zoned LDR MH and was purchased 13 May 2024. I have good service via signed certified mail receipt and posting at the LaCanto Government Building. I'd like to authenticate the following documents and request that they be admitted into evidence.
Well,
Exhibit.
I'd like to see if that's necessary first.
Okay,
I
sure.
just want to
Yeah,
see,
absolutely.
are you contesting whether or not there's a
I have
violation?
no idea what I'm doing. I know that we had stuff on the property and we're bringing it into compliance.
Well, this is a junk case, so it sounds like there's some junk on the property.
Yes, there was.
There was, but you
Yes.
aren't sure whether there is today.
Well, I know when I talked to him, when did I call you?
Yesterday.
Was it yesterday? He told me what was, or it was the day before yesterday.
We
'Cause I
spoke
started-
yesterday too, because I told you
It
what was
must have been a
still
long,
there.
you had a long night.
I talked to him and I have since removed all of that, which he told me if I showed you pictures, you had to keep my phone, so you can't keep my phone.
That's correct. That's correct.
So I'd like to keep the
All
phone.
right, then let's
but-
walk through this, because if there's any uncertainty, I apologize. Yeah,
No, no
go
worries.
ahead.
Photos taken during my initial inspection on 7 April 2025, photos from a compliance inspection on 7 May 2025, and photos from my final inspection conducted on 16 June 2025. Wait, I'm sorry, that may be a typo. Yeah, 16 June 2025. Exhibit B, copy of the notice of violation, a copy of the notice of hearing, a copy of the signed certified mail receipt, and a copy of the pre-hearing order.
So ma'am, I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence.
Well, that's definitely my property.
Those are from the 16th, Monday.
No, that's all been, like I said, you have to come back out.
Those are the blankets we were talking about.
Yeah, I had just worked on 2 cars.
And then looks like a mattress or something is up against the shed there.
Okay, that might not have been moved, but that's a shower wall. Yes.
Okay. That would be junk.
Okay. I'm learning the definitions of everything now. Getting there.
Different people, you know, have different
Yes.
feelings and thoughts and definitions about what constitutes junk sometimes.
Yes.
And certainly my mother and I did. All right. Let me just take a look at the, okay, exhibits A and B are admitted as evidence, and I'm just gonna quickly look through here. Yeah, yeah. Anything else you want to tell me?
No, sir.
All right, I mean, it does look to me like there's some, it's not high on the junk scale, it's on the lower half, but it's still there. How much time do you need to bring it into compliance?
I've brought all but the shower wall that he pointed out on the one thing. I've already brought everything back in.
All right, I want to give you enough time, so is 10 days enough?
Yes.
What-
Now, I do have a question. Is there an issue with my garbage cans where they're sitting?
As long as they have lids on them, you're fine. You don't have to go get
Okay.
lids.
I'll figure that one out. And I do have another question. Y'all were talking about vines earlier. I have the corner.
We can talk, we'll talk after.
Okay, okay.
I'm only going to deal with this case that's in front of me, but, you know, can you get this done in 10 days?
I've got most of it done.
Okay. Is there anyone from the public who wants to be heard on this case? I'm seeing someone shaking his head, absolutely not. Nope, nope,
husband.
nope.
That's
Okay.
my husband.
What's the county's recommendation?
$150 a
$150.
day.
All right, so I'm gonna grant 10 days. If it's not brought in compliance in 10 days, there'll be a $150 a day fine.
Okay.
How big is the property?
1.17 acres.
It's a good size. Okay, well, good luck.
Thank you.
Thank you, ma'am. Just give me a call.
Okay.
Next case, Fred A. Brakey and Laura M. Miller, case number 2025-131. Code Officer Erica Olson, page 8 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Go ahead.
Erica Olson, Citrus County Code Compliance Officer. This is case number CE 2025-00131. Special requirements for all accessory structures, a violation of the Citrus County Land Development Code 3102 Alpha. The address is 11468 East Maid Court, Inverness. It's 0.34 acres in a zone CLR MH. Property owner is Fred A. Brakey and Laura M. Miller. I've got good service via posting on the property and posting at the Lecanto Government Building. I'd like to take the time to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on the 29th of January 2025, photos during my compliance inspection on the 20th of February 2025, and photos of my final inspection conducted 16 June 2025. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, a copy of the continuation letter, a copy of the continuation letter posted on the property, and a copy of the posting affidavit.
Okay. Exhibits A and B are admitted as evidence. Is there anyone from the public who wants to be heard on this case? I don't see anyone. Go ahead.
On the 29th of January, I conducted my initial inspection and observed the property to be in violation. There is an RV parked on the property and a notice of violation was issued for the above mentioned violation. On the 20th of February, a compliance inspection was conducted with no change to the property and a notice of hearing was sent. I have not had contact with the property owner. Due to lack of service, a letter of continuation was sent on the 19th of May 2025 advising of the hearing today. As of my final inspection on the 16th of June, the property remains in violation.
What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $150 per day along with administrative costs to begin after the date that you deem sufficient to abate this violation.
10 days and $150 a day.
Thank you, sir.
Thank you.
Next case, Boris Blant, case number 2025-461, Code Officer Alan Jonason. Page 6 of your agenda, expert on the case, Land Development Director Joanna Coutu.
Oh, I'm not as good as Judge Judy. She's the
I
best.
beg to differ.
Yeah, right.
I beg to differ.
Man, I was watching
Yeah,
clips of her the other day. She's good. Gosh. If we could get her here. She's,
I'll work on it.
yeah, all right.
See what I can do. Alan Jonason, Citrus County Code Compliance Officer, case number 202500461, Citrus County Land Development Code, Section 4002, site development without a development order or permit. Address of the violation, 4275 South Culver Terrace, Inverness, Florida. Property owner is Blant Boris. This property is 0.22 acres and is zoned MDR and was purchased 1 February of 2006. Exhibit A, I have good service via posting notice of hearing on the property and posting at the Lecanto Government Building. I'd like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 31 March 2025, and an aerial photo from the property appraiser's website from 7 May 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a photo of the notice of hearing posted on the property, a copy of the posting affidavit, and a copy of the pre-hearing order.
Exhibits A and B are admitted as evidence. I don't see anyone else in the public anymore, so I'm going to stop asking for public input. Please proceed.
On 31 March, I conducted my initial inspection and observed the property to be in violation. On 31 March 2025, a notice of violation was issued for site development without a development order or permit, which is a violation of the ordinance I mentioned earlier. On 30 April 2025, I conducted research with no permits issued, and as of my final inspection on 17 June 2025, the property remains in violation, and I have had contact with the property owner.
You have, and how did that go?
So this gentleman lives in Minnesota, owns this property. There is a new home that's being put up next to this property, and the construction company mistakenly cleared the lot. I explained to him he's still responsible. I said my suggestion would be to contact an attorney and recoup whatever costs are due to this.
So you know that he didn't do it?
Well, that's what he said. I don't know
I
if it's
see.
true.
Okay.
I don't know if it's true, but that's what he indicated to me. So,
I am aware that this does happen from time to time
Sure.
in Citrus County.
Absolutely.
Because I had
it's like when people put junk on your property.
right. But I don't, if that was true, I mean, I don't think I'm going to find it. I'm just saying, if someone cleared someone else's property, I don't know that I could hold them. Like, if it was a mistake, I don't know that I could hold them responsible.
I asked him if he had any proof of any of that. He did not.
No, and I don't have any in front of me.
County believes you could hold them responsible because they're the owner of the property and the definition of violator.
Yeah, but the thing about it is that, you know, there's the measures that someone would have to take to prevent it. I don't know. I think that's really a difficult ask. In any event, in this case, I don't have any evidence really of that. He's not here to explain as well. So what's the county's recommendation?
$5,000 and administrative fees.
Okay, I'll do a one-time fine of $5,000, find the property in violation.
Thank you.
Thanks.
Next case, David A. Brasky, case number 2025-502, Code Officer Erica Olson. Page 7 of your agenda, expert on the case, Land Development Director Joanna Coutu.
Erica Olson, Citrus County Code Compliance Officer. This is a repeat violation initially observed on the 4th of April 2025. Case number CE 202500502, home occupations in residential districts, a violation of Chapter 3, Section 309 of the Citrus County Land Development Code. Property owner is David A. Brasky and has been previously found guilty of the same violation at the same location on the 18th of September 2024, case number CE 2024-01086 with $0 and imposed fines. This case was abated on the 15th of October 2024. The address is 6950 West Sedate Court, Homosassa, Florida. It's 1 acre, zoned RUR-MH. I've got good service, posting on the property and posting at the Lecanto Government Building.
Okay.
Let me go through. At this time, I'd like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, the findings of fact and order acknowledging compliance for the previous case, CE 2024-01086. Exhibit B, photos taken during my initial inspection on the 4th of April, 2025. My subsequent inspections on the 22nd of April, the 5th of May, the 19th of May, the 21st of May, 2025, and my final inspection the 16th of June. A screenshot of their Facebook page and the Better Business Bureau's screenshot and a copy of the Sunbiz. Exhibit C, a copy of the notice of violation and notice of hearing sent to David A. Bresky, a copy of the posting affidavit, a copy of the amended NOV and NOH, and copy of that posting affidavit, a copy of the NOV and NOH posted on the property, a copy of the certified mail return receipt, a copy of the general pre-hearing order, a copy of, and a copy of the notice of hearing posted on the property.
Exhibits A, B, and C are admitted as evidence. Have you had contact with the owner?
No, sir, I have not.
Okay, thank you. I'm just gonna look through it real quick. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests the special master assess a fine of $200 per day with administrative costs to begin after the date of posting on the property, the 4th of April 2025, and continue until the 17th of June 2025. That would be 74 days, $200 a day, totaling $14,800, and a fine of $250 per day from this day forward until the violation is abated.
Is there anything else you wanted to tell me about the case?
It's just they're running a tire shop out of, I don't know if you remember the previous case.
I do. I mean, there aren't many of these that we've had.
Right.
Yeah.
They continue to post on Facebook. I've been to the property. I haven't made contact with a property owner, but I did make contact with a customer. She said that she had Googled, and this was the first tire shop that came up.
Really? Wow.
But she said that no one was answering. They had an open close sign, and it was flipped closed. So
those are things we customarily associate with businesses, or in this case, a home occupation.
And they do advertise. They have an active Facebook page.
Ms. Wilkinson, you had the prior case, I believe. Would you mind coming up? Did you ever have contact with the owner?
Yes, actually, on one of my, if I recall correctly, I might have details lost, but in one of my first inspections, I went up there and told them that they couldn't have the tire shop, and it was originally a junk case, and I think, a home occupation case, yeah.
Okay. I mean, okay, all right, that's what I was wondering. Thank you.
You actually had the junk case again last month.
And
they failed their compliance inspection on Monday, so.
Well, what I'm going to do is I'm going to find that this is a repeat violation and do $200 a day from April 4th until, I think you said the 16th?
The 17th yesterday.
Okay, then the 17th, and then $250 a day from today's day until it's fixed.
Thank you, sir.
Thank you.
Next case, Scott A. Bronke, case number 2025-599, Code Officer Julie Wilkinson, page 9 of your agenda.
So I like Judge Caprio more than Judge Judy, by the way.
Wow. Well, there's a first time for everything, but, you know.
Okay, case number 2500599, accumulation of junk and debris. This is a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. Sorry, this paper clip has got me all messed up. The address is 3910 North Rock Jasmine Point in Beverly Hills. The property owner is Scotta Bronchi. That's what it says in the thing. I'm not sure if it's supposed to be Scott A. Yeah. Have good service via posting the notice of hearing at the property and at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on April 24th, 2025. Photos from a corrective action inspection on May 13th, 2025. And photos from my final inspection conducted on June 17th, 2025. Exhibit B, a copy of a notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, photos of the notice of hearing posted at the property, and a copy of the posting affidavit.
Exhibits A and B are evidence. Thank you. I'm just going to look briefly through this. You took the photos on the dates indicated in Exhibit A.
Yes.
This looks like a comprehensive, good old-fashioned junk case.
Where do you think it is on the scale?
Yeah, I mean, it does appear to me, I mean, I've seen more junk on bigger properties, you know, but for this small of a property, I don't know, it's a 7. What do you think?
I was thinking maybe an 8.
I mean, it's close, but I mean, I can see grass. What is the county's recommendation?
$150 per day.
Okay. Hey, well, let me just look. Have you had contact with the owner?
No,
Or tenants or anybody?
nobody.
Yeah, okay.
But stuff is being moved around and new stuff added, so somebody is there.
Okay. Well, my first instinct on these kinds of cases without hearing from the person is to give 14 days. So I'm going to give 14 days and 150.
Thank you.
All right.
Next case, Don C. Dietrich and Sarah J. Kone. Case number 2025-676, Code Officer Cody McGuire, page 14 of your agenda.
All right. Cody McGuire, Citrus County Code Compliance Officer, case number 202500676, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. Address is 485 South Little John Avenue in Inverness. The property owner is Don C. Dietrich and Sarah J. Kanye? Dietrich, sorry. Coin? Okay. Sarah J. Coin. Good service via posting the property, or posting the notice of hearing on the property and posting on the Canto Government Building. I'd like to authenticate the following documents and request they be admitted into evidence. Exhibit A is photos taken during an initial inspection on May 5th, 2025, corrective action inspection on May 21st, 2025, and photos of my final inspection on June 16th, 2025. Exhibit B is a copy of notice of violation, copy of notice of hearing, copy of the general pre-hearing order, photo of the notice of the hearing posted on the property, and a copy of the posting affidavit.
Exhibits A and B are admitted as evidence. Thanks. Okey-doke. You took the photos on the dates indicated?
Yes, sir.
This is also not a good junk situation.
No, sir, it's not.
Have you had contact with the owner or occupant of the property?
No, even after posting it, they removed the sign, but not the junk.
There's a certain irony in that, I guess. Has there been any improvement in your view?
It looks,
It does look like there's been a little bit of improvement.
I understand making a mess to clean a mess, but
Mm.
I don't think there was much of an attempt to clean.
From May 21st to June 16th, it looks to me like there was a little. All right, what's the county's recommendation?
Due to the severity of that, it's $300 a day.
Okay, 14 days, $300 a day.
Next
Thank you.
case, Fifth Seven Construction Group LLC, case number 2025-516, Code Officer Julie Wilkinson, page 15 of your agenda. Expert on the case, Joanna Coutu.
Case number 2500516, special requirements for all accessory uses. A violation of Citrus County Land Development Code 3102A. The address is 1282 West G Martinelli Boulevard, and property owner is Fifth Seven Construction Group LLC. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Photos taken during an initial inspection on April 9th, 2025. Photos taken during a corrective action inspection on April 25th, 2025. And photos from my final inspection conducted on June 17th, 2025. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
Exhibits A and B are evidence. Thank you. Tell me about this.
So this is a vacant, essentially a vacant property. They never got a CO and.
So they got a permit, they built, they didn't finish.
Exactly. Their permit expired November 26, 2024.
And now, although they did build what's on there pursuant to a permit, it's expired and now they're essentially storing.
Yes.
Or keeping something there.
Yes.
Without the use being established.
Mm-hmm.
Okay. And we've been through this, it makes sense. It's hard, it's a little hard for me to instantly wrap my mind around, but it does make sense. I mean, I guess what you're saying is that anytime a permit expires without the CO, you've got a violation of 3102.
Yeah, because without the CO, then the primary structure isn't established.
When did the permit expire?
November 26, 2024.
Have you had contact with the owner?
No.
Okay. All right, what's the county's recommendation?
$100 a day.
Would getting a new permit abate it?
Getting a new permit would reestablish the use and continue them to allow construction, but it won't let them just sit there forever, so.
Well, I guess, but you know what I'm trying
It
to
would
get at.
start the clock again for them.
If they start, yeah, exactly. So
They-
it would abate the violation because it's pursuant to a permit.
As long as the permit remained active, yeah.
Right.
Right,
And
yeah.
All right, then I'll grant, let's see, let's look at this. When did you initially send notice out on this case?
On April 10th, I sent the notice of violation.
All right, 14 days, $100 a day.
Thank you.
Next two cases, Vanessa Fuenmayor, case number 2025-667, and 2025-668, Code Officer Julie Wilkinson, page 16 and 17 of your agenda.
All right. So case number 2500667, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances, and case number 2500668, excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 20-61 of the Citrus County Code of Ordinances. The address is 11 South Tyler Street in Beverly Hills. The property owner is Vanessa Fuenmayor. I have good service via posting the notice of hearing on the property and at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on May 1st, 2025. Photos from a corrective action inspection on May 16th, 2025. And photos from my final inspection on June 17th, 2025. Exhibit B, a copy of the notices of the notices of hearing, copies of the notices of violation, copies of the general pre-hearing order, and a copy of the notices of hearing post at the property, and copies of the posting affidavit.
All right, exhibits A and B in each case are admitted as evidence. First, I'm going to look through the overgrown, unkempt lawn case. These are my favorite cases. Well, what's your case here?
The backyard was overgrown, and then as time went on, portions of the front yard became overgrown.
Okay. Yep, all right, I see it. And let's see, on the junk case, yep. Have you had contact with the owner?
No.
No? What's the county's recommendation?
$100 a day for each case.
All right, and you took the photos on the dates indicated for each of the set exhibit A's?
Yes.
All right. I think the photos explain the situation. I think they're self-explanatory. And what I'll do is I'll grant 14 days to correct each, and if each is not brought into compliance as ordered, there'll be a $100 a day fine.
Thank you.
Thank you.
Next case, Helm Housing LLC, case number 2025-588, Code Officer Erica Olson, page 23 of your agenda.
This is a lawn case, which is
Good,
apparently
good,
your
good.
favorite.
It's about time. I don't know what happened. These hearings used to be all lawn cases.
This one isn't that good, though.
Now they're all. Now they're all. Well, that's true. That's true. That is true. That is true. But I think as a general proposition, they're still on the downswing, and I think y'all really need to bring them back.
Pick it
We
back
get a
up.
lot of 3102s, a lot of 4,000. I mean, those. I don't know if they even existed when I started, but because I never saw them for years. But all right, you guys are cleaning the county up. You're doing what you got to do. I'm just saying, I think grass is a bigger issue, and I'd like to see more.
What?
I'd like to see more
What?
overgrown grass cases. If my preference matters, which it doesn't.
So if we're gonna start a grass scale, I would say this is maybe a 2.
Be careful, because your 2 might be not a 1 for me. So let's take a look. Let's take a look.
The address is 11793 West Fisherman Lane in Homosassa. The property owner is Helm Housing. I've got good service posting the notice of hearing on the property and posting at the Lecanto Government Building. I'd like to authenticate the following documents and request that they be admitted into evidence. Exhibit A is my photos taken during my initial inspection on the 22nd of April, 2025, corrective action inspection on the 7th of May, and photos of my final inspection on the 16th of June. Exhibit B is the normal paperwork, copy of the notice of violation, copy of the notice of hearing, copy of the posting affidavit, a copy of the notice of hearing posted on the property, and a copy of the sunbiz.
Okay. Exhibits A and B are evidence. Thank you. Oh, this isn't a 2. What are you talking about?
It's so at the front of the property, I can't like measure without trespassing, which we don't do. So at the front of the property, it's really not overgrown, but towards the side of the property, it's really the weeds.
I definitely think it's obvious from the photos that it exceeds 18 inches. I mean,
Definitely.
yeah.
I mean, it probably would come up to my waist at least. I am 60.
Oh yeah, this is.
I think.
Listen, if you think this is a 2,
I think it's a 2.
wait
I
till
really
you,
don't
wait
think
till
it's
you
that
see
bad.
a few. Well, what's your recommendation?
The county recommends a fine of $100 per day with administrative costs.
7 days, $100 a day.
Thank you.
Ernest Richard Marshall and Jeanette Mae Jackson, case number 2025-629, Code Officer Alan Jonason, page 27 of your agenda.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 2025-00629, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. Address is 3020 North Anthony Avenue, Hernando, Florida. Property owner is Marshall Ernest Richard and Jackson Janet May. This property is 2.30 acres and is zoned LDRMH and was purchased on 8 March 2021. I have good service via posting the notice of hearing on the property and posting it at the Lecanto Government Building. I'd like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 5 May 2025, photos from my compliance inspection on 27 May 2025, and photos from my final inspection conducted on 16 June 2025. Copy of the notice of violation, a copy of the notice of hearing, a photo of the notice of hearing posted on the property, a copy of the pre-hearing notice, and a copy of the posting affidavit.
Exhibits A and B are evidence. It used to be that y'all did your final inspections like the day before the hearing, but it seems
If
like.
we have multiples, we split them up
Split
into
'em?
those.
Okay.
Yes, sir, just because there's a lot of paperwork involved.
Oh, that makes sense. The only issue is an evidentiary one where if they come in and say, well, I cleaned up yesterday.
Sure.
You know what I mean? So
Sure.
that's fine.
Understood.
All right, evidence is admitted. You took the photos on the dates indicated?
Yes, sir.
Oh, I see.
It's tree debris.
Yeah, that's a lot of it.
It is.
Have you had contact with the owner?
I have not.
What's your recommendation?
$150 a day plus administrative fees.
Okay, 14 days, $150 a day.
Thank you.
Next case, Melody C. Negengas and Katie Edmond and Stephen Sosa. Case number 2025-493, Code Officer Julie Wilkinson, page 28 of your agenda.
Case number 2500493, excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 20-61 of the Citrus County Code of Ordinances. The address is 159 West Golden Tuft Court in Beverly Hills. The property owner is Melody C. Nagengast, Katie Edmond, and Stephen Souza. I have good service via posting the notice of hearing at the property and at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on April 8th, 2025. Photos from a corrective action inspection on April 23rd, 2025, and photos from my final inspection conducted on June 17th, 2025. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, photo of the notice of hearing posted at the property, and a copy of the posting affidavit.
Exhibits A and B are admitted as evidence. Thank you. Have you had contact with the owner?
No, I have had contact with the neighbors, and she said that she hasn't seen anybody at the property in a while, and it's been a neighborhood effort to keep the grass mowed, and I think they're just not mowing it anymore.
Right. What's the county's recommendation?
$100 a day.
And you took the photos on the dates indicated in Exhibit A?
Yes.
All right, then I'll grant 14 days, and it'll be $100 a day.
Thank you.
Next case, Rusty Snyder, case number 2025-520, Code Officer Alan Jonason, page 33 of your agenda.
Did we skip Rodriguez?
Oh, I'm sorry, I did.
It's no big deal, I just, yeah,
ahead, Alan.
Snyder's fine, I was just curious. If it was abated or not, yeah.
Alan Jonason, Citrus County Code Compliance Officer, case number 2025-00520, accumulation of junk and debris, violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. Address of the violation is 4208 East Lake Park Drive, Hernando, Florida. Property owner is Snyder Rusty K. This property is .36 acres and is zoned CLR MH and was purchased 9 April 2019. I have good service via signed certified mail receipt and posting into the Lecanto Government Building. I'd like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 10 April 2025, photos from a compliance inspection on 12 May 2025, and photos from my final inspection conducted on 17 June 2025. Exhibit B, a copy of the notice of violation, copy of the notice of hearing, a copy of the signed certified mail receipt, and a copy of the pre-hearing order.
Exhibits A and B are admitted as evidence. You took the photos on the dates indicated in
Yes, sir.
Exhibit A. And have you had contact with the owner?
I have not.
Has there been improvement?
There has not.
No. There has not been. What is your recommendation?
$150 per day along with administrative fees.
Okay, 14 days, $150 a day.
Thank you.
Next case, Armando and Colette Rodriguez, case number 2025-675, Code Officer Cody McGuire, page 30 of your agenda.
Cody McGuire, Citrus County Code Compliance Officer, case number 2025-00675. It's accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. Address is 461 South Little John Avenue. Property owner is Amato and Colette Rodriguez. Good service via posting the property and posting at the Canto Government Building. I'd like to authenticate the following documents and request to be admitted into evidence. Exhibit A, photos taken during initial inspection on May 5th, 2025, corrective action inspection on May 21st, 2025, and photos of my final inspection on June 16th of 2025. Exhibit B is a copy of the notice of violation, copy of notice of hearing, copy of the posting affidavit, and a photo of the property posted and a pre-hearing order.
Those exhibits are admitted as evidence. You took the photos on the dates indicated,
Yes, sir.
and has there been improvement?
There's just a few things that remain on the property.
You've had contact with the owner?
Yes, sir, I have.
Has that been positive?
One time, another time when I pulled up, he just didn't want to talk to me, I suppose.
What remains to be done?
So there is like a dining room chair on the front porch and a ladder that's stored on the roof.
I don't think the chair is, why is that chair in violation?
It's more of an indoor chair than an outdoor chair.
Looks like it's in a place where it can be used. It's not exposed to the elements per se, it's under the, I agree with you about the ladder. So I'll sustain that there is a violation, but I don't think the chair is a violation.
Okay.
All right, I'll grant 7 days. What's the county's recommendation?
100 per.
$100 a day. Thanks.
Thank you.
Next case, last case, Eric J. Stanley, case number 2025-652, Code Officer Alan Jonason, page 34 of your agenda.
Williams is not on there?
No, it's closed,
It's
I'm
closed,
sorry.
okay, great.
Alan Jonason, Citrus County Code Compliance Officer, case number 2025-00652, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. Address of the violation is 202 Hofstra Street, Inverness, Florida. Property owner is Stanley Eric J. This property is .22 acres and is zoned MDR and was purchased 13 September 2022. I have good service via posting the notice of hearing on the property and posting at the Lecanto Government Building. I'd like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 5 May 2025, photos from a compliance inspection on 27 May 2025, and photos from my final inspection conducted on 17 June 2025. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the posting affidavit, a photo of the notice of hearing posted on the property, and a copy of the pre-hearing order.
Exhibits A and B are admitted as evidence. Thank you. You took the photos on the dates indicated?
I did, yes, sir.
Did you have contact with the owner?
I have not had contact with the property owner.
Has there been any change
There is
over
not.
time? On cases like this, do you develop any theories about what might be happening? Like, are they just absent landlords? Have they passed away? Like, do you ever find that out or something?
Unless something comes to me, no idea.
Well, I think the photos are self-explanatory. It's not a huge junk case, but it's
Right.
clear.
Yes, sir.
What is your recommendation?
$150 a day plus administrative fees.
Okay, 14 days, $150 a day.
Thank you.
Is there anything else that the county needs to take up before this hearing is adjourned? Okay, the time is 11:10. I think your case resolutions did a lot to accelerate this today, so. Yeah.
We're working on those.
No, that was great. All right, thank you.